Hope everyone enjoyed the video testimonials of the participants. If you also wish to join the 24-hour intermediary mediation training, details are in the chat box. Without any further ado, let us begin. Welcome one and all to the interactive Fireplace chat with Ms. Kathleen Joanna and Ms. Maureen Erickson Robertshaw. About MediateGuru. MediateGuru is a social initiative led by members across the globe. The aim of the organization is to bridge the gap between the general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future. Having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 100 countries around the world, with an international family growing each day, we strive to provide you with the best lecture series through the best speakers around the globe so that you can have a value addition today. I feel honored today to welcome our esteemed speaker for the session, Ms. Kathleen Joanna and Ms. Maureen Erickson Robertshaw. Kathleen Joanna is a mediator at Pierce County Center for Dispute Resolution, Washington. She's first court juror, US. She's a former divorce mediator at Norfolk Probate and Family Court. She's a former court and training coordinator at Family Services of Central Massachusetts. She's a former summary process mediator at Quincy District Court. She's a former small claims and divorce mediator at Plymouth Family and Probate Court. She's a former small claims and summary process mediator at Cape Mediation. She's also a former executive assistant to CFO and VP at Ram Power Corporation. Former health educator at Greencastle Antrim School District. She studied Master of Education at Shippensburg State University and studied Health and Physical Education K-12 at Shepherd University. Ms. Maureen Erickson Robertshaw is a Harvard Law School trained negotiator, family law mediator, custody evaluator, parenting time expeditor, Rule 114 qualified neutral, and parenting consultant. Maureen teaches internationally on the subjects of intimate partner violence and mediation, has taught law students in 43 countries. She earned a certificate in conflict resolution from Cornell University, completed Harvard Law School's program on negotiation, and is an alumna of Massachusetts Institution of Technology Sloan School of Management. She holds a seat on the Minnesota State Bar Association's Alternative Dispute Resolutions Council and is on the board of directors of the Boys and Girls Club of Northern Minnesota and member of the Young Intervention Program Association's Training Committee. She worked with high-conflict families for many years through the Wellstone's Family Safety Program and has trained in child growth and development and addition dynamics. I would request the speakers to take the session forward and enlighten us all. You all can ask your questions in the chat box. You are on mute.
Hello, can you hear me, Maureen? Hello. We have to do an IT check first, I think.
Oh, can you hear me? I apologize.
Yes. Hi. It's been a whole year since you presented. How are you?
I am lovely. I am so excited for everyone here and to talk with you, Kathleen, which is always awesome.
Well, thank you. And I was looking at the video about the class that I just had, but you have a class coming up. Can you tell us about that before we start chatting?
Sure. I am doing some career counseling one-on-one with students. on Wednesdays. You can go to MediateGuru to find the details, but I would love to talk to you about your goals, where you'd like to be, and if I can be helpful in helping you get there.
That sounds incredible. So what have you been up to for a whole year since we last talked together?
It has been such a busy year, Kathleen. Both of us have done so much with MediateGuru, and with the pandemic, both our practices have changed a little bit. How has yours been different?
A lot of virtual mediations. And I notice I have a bit of a different style, when I'm on a virtual mediation via Zoom, as opposed to face-to-face. And I didn't notice it right away until then I started to look back at my cases and say to myself, oh, I have a different style. So it's been a lot of that. And then, of course, you and I, we've been doing a lot of training and judging in law school mediation tournaments. So I love the fact that virtually we can go anywhere and sit here in our house or apartment, and we can really go anywhere. And I think we have a worldwide neighborhood now. Lots of people, in mediation. Our practice has changed so much. I feel like the world is our neighborhood, our backyard, our front yard, our side yards. Yeah.
That has been, like, as horrible as the pandemic has been, which it has been so painful for so many. That is one really, really small silver cloud. But for mediation, it has been huge. We've been able to connect across the world. And I think for the consumers of mediation, they've been able to find very niche expertise that they need in their mediators. They have so much more of a choice and style. And I think it's really become more, people have been able to access it so much better, especially at much lower price points, because that's always an issue with mediator travel costs or lawyer travel costs, time, and just being so restricted in that sphere. It seems like it has exploded to help so many more people. Have you found that in your practice?
I agree. It's so much easier. And yes, we're not driving anywhere. We're not flying anywhere. We don't need to have an office. During the pandemic, I actually left my offices in Massachusetts and came down to a work apartment in Texas, El Paso, Texas. And I have a work apartment in LA as well. Actually, I share it with my daughter. So it's, from here to LA, it's an 1.5-hour plane trip, which is very easy. I would drive, from Cape Cod, Massachusetts for an 1.5 hours just to get to the Boston area in my car. And that was, that was a typical drive. So an 1.5-hour airplane ride works for me as well.
I live up in northern Minnesota, and in Minnesota, the two largest cities and basically the metro area is about 4 hours from me. Mm-hmm. And then Duluth, Minnesota on Lake Superior is about an 1.5 hours. And I did a lot of traveling prior to the pandemic. And this is so much better. I can go anywhere now, and I can offer so much more rested, when you're not making a 4-hour drive.
Yeah. And we have our homebrewed coffee as well to enjoy.
One thing I've been really curious about with the change, I've been so curious about the psychological differences for the clients. Is it sometimes the environment that we would do mediation in, whether it was our offices or law office or conference center? I wondered what effect being in an artificial environment had on them, and whether we're getting more authentic agreements when they're in their own homes, in their own space where they feel safe, and they can also visualize how it would work, whatever plan we're talking about, better. Do you think that that's possible, that it'd be a more authentic agreement because it's more a part of their life than a more sterile environment?
I don't know. I don't know. I've never asked after the mediation, and with this mandatory mediation from the courts that we're experiencing in our country and other countries, and then, being virtually present, in the mediation, I just don't know that impact. I know for me as a mediator, when it gets a little bit more intense in the mediation, I work less. I don't work as hard in the virtual mediations because I'm not there to put my hand out across the table. I'm not there I'm physically not present. So I won't do a deep of a dive into mediation for clarity as I would if I was there in person. So it's definitely affected my style. And I don't know if that's good or bad. I just know that I feel this barrier, and I won't do it. or I need to practice doing it. I don't know
which. Do you find that when it's, most of my clients, it's a very emotionally raw situation, because I usually deal with allegations of abuse at the end of custody or visitation or marriages and partnerships. I find I'm more exhausted after Zoom mediation. I think that there's something when you're in person, I'm not sure if it's an energy flow thing or the connection, but I think that it's harder to make the connection over Zoom. Totally worth the effort, but I'm more exhausted after a 2-hour Zoom mediation than I would be in person.
Oh, that's interesting. That's good to know. So what do you think of the mandatory mediations delivered down from the courts in our various states and also countries across the world? What's your take on them? Because for the US, it's kind of fairly new, and places like, Atlanta, places, in the state of Georgia and other states, they've been doing it for a while, but for most of the United States, this is like new news. Mandatory mediations? What are your thoughts on it?
My thoughts are kind of scattered. I'm seeing a lot of pros and a lot of cons. In Minnesota, I think it's been over 10 years now, where I can't remember the last time I've seen a court order that didn't have a mandatory mediation clause before they came back. So I guess it's complicated when I look holistically at the justice system and at our courts and custody. It is not built to take the amount of cases that we have, and so people have ridiculously long waits. I have seen, it seems, when it's ordered really early on, I think it's much more effective before people are kind of pushed already into their own position because of how much they've spent financially and emotionally in custody. So I think earlier on works better, but I also really worry about people just checking a box and how that devalues mediation and mediators. When someone shows up to check a box, it's not, people really aren't present to work. So on the one hand, more people know about ADR now. On the other hand, it might be devalued. It's also really hard, as I'm sure, I don't know how you explain it, that mediation is a voluntary process, but you're here because you have to be. Like, that's always a really fun conversation.
Yeah, I like the fact that you're a lawyer and I am not a lawyer, and we can talk about it from both sides of the coin. I can totally understand. And what's the long caseload in Minnesota? What are you talking about when you have to wait for a case in Minnesota? What's a long wait? Excuse me.
A long wait would be more than a year.
Okay.
So sometimes you'll have your initial case management meeting, and then you may not get to trial about that custody for a year or 2 years. And sometimes our trial dates are so different than what people think, where you may have one date of trial in July, the second date of that trial maybe in November, January. So I don't even know how the justices keep all those dates in their head, like the continuity of the case when you have a 4-day trial, but it's conducted over 9 months. So the wait is such an issue.
Yeah, the clerks have to do a lot of work for the justices to keep everything organized. That's for sure.
Well, I don't know how they remember what people say, because obviously there's not all, especially custody, have transcripts. So it's down to the judge's notes then. And I'm really curious how they recall from July, whether they found someone credible or to January. And we see so many continuances for months and months and months, which really puts kids in a very limbo system, especially if your family is changing. Having that support for children is so important, knowing what's coming next. And for months and months, they have no idea. I do need to clarify, though, I am not an attorney.
Oh, my gosh. I thought you were. Thank you for that. How did I think you were an attorney all these months?
I don't know. Is it because I say it depends? Because my friends who are all attorneys, they're like, oh, you're an honorary attorney if you say it depends to every question. It's more of a therapy question. Like, it depends. Tell me more.
Oh, my gosh. Thank you for that clarity.
So how does it work for you? How do you see the mandatory conversation?
Well, from looking from the court's perspective, they're using the right word. Our courts are too full, so we're going to mandatory out mediation. From the mediation perspective, it's so the wrong word. They're giving us clients through a mandatory process that we're telling them, as you said, oh, it's voluntary, by the way, and when they get there. It's really, I think it's one of the clearest differences between the court and mediation. It's right there for all of us to see. We have to respect that court mandate. Of course, we have to respect it. It's the order of the law. And then when people come to us, then we have to educate them about our process. So, a lot of people that I know, we're kind of, King Solomon split the baby. We're kind of splitting the baby. We're saying, to make it palatable, we're saying, well, thank you for keeping your court mandated appointment. And now that you are here, let's see what we can mediate. Let's see what we can do. So we're actually making distance between what the court has said you have to do. You're here. They can literally get up and walk away because they've kept the appointment. And since you are here, you have now stepped into the mediation process. So let's see what we can accomplish. Some of the states are mandating that these mediations be done in good faith. And they're saying about the mediator that the court can ask the mediator, was this mediation done in good faith? And so now it's our subjective mediator opinion that comes forward to the court, and we can say yay or nay, which I think is super scary because we're supposed to be not available to the courts with information about how a mediation has gone. So I do
feel that's an ethical issue for mediators, because I will confirm to a court whether a mediation has taken place, even if that mediation is only, because I do tell people, you just have to show up. You don't have to say a word. You can leave 2 minutes after we're there. And I feel ethically that it's none of the court's business. And unless I am absolutely directed or subpoenaed, I'll give you a letter saying you came. But how do I know what good faith is? I don't. And asking me to make that choice, I feel really violates our neutrality.
Yeah, that good faith, I call it provocative because it's under interpretation of anyone there at the table. And what makes my opinion about good faith, more valuable than someone else's opinion, including counsel at the table. We all might have a relative idea of good faith. And a thought I had when you were talking is the fact that now we're taking our valuable opportunity of mediation, and it's kind of like you have to show up now that you're here. The value is being diminished, I think, when actually I wish the court would come up with a new name, like the last stop or something is better than mandated mediation, because clearly mediation, as we all know, has so much value because it's the last place where people have 100% power and control over their own outcome. And we're not talking about that. We're not talking about how special that is. As a courts coordinator and trainer for a while, and being involved with the courts for over 15 years, when people go into the courts, somebody else is rendering a decision about their life. And the judge is choosing this and choosing that for people. And the decision is out of their hands. And I've seen people in court try to stand up and talk to the judge. And it's like, no, that time was back in mediation. And the judge is not going to talk to the parties anymore. The judge is going to speak to their advocate, the attorney who represents them, who the court acknowledges. The attorney has a relationship with the court, number one, and secondly, with the clients. So we're really skipping over the value of mediation. I wish the court would have coined a term saying something like, we want to give you this valuable opportunity of sitting at the mediation table with the people that are most familiar with your life. And then if you can't work it out at this last stop opportunity, then you may come to the court and we will decide.
I do feel like how often I hear from people that they just want their day in court, have never been to court. And I feel like what they're really asking for is what they get in mediation. They get to tell their story. They get to say how they feel, how it's impacted them. Everyone listens, and they get that really valuable experience of hearing that from the other person. Mm-hmm. And I feel like that's really what they want when they say they want their day in court. It's that being heard, which is not what you will get in court. And I do tell clients not to scare them or terrify them into agreeing to something, because you don't want someone to make an agreement that is not authentic and what they will keep. Mm-hmm. But you may end up in court and it's not your way or the other person's way. It might be something you both hate. Like this person doesn't have enough time and they don't have enough wisdom about your life, your kids, what you guys want your family to look like, or whatever the conflict may be. Mm-hmm. You get to shape that here. There you have no idea what you'll get. And sometimes they're back in mediation because both of them hate the court order.
It is shocking sometimes to hear what judges order. You know, we always tell people we can never tell you what a judge will decide. And sometimes I have been very surprised because the mediations for me, when I used to do that work all the time, the ones that didn't settle, I would go sit in the court to see what would happen because I was curious. And sometimes, as I mentioned, I was just very surprised. And judges will do what judges want to do based on the law and their interpretation of the law. And I also, when I hear, I want my day in court, I hear that as a scream for justice. I want my justice. And I've told people, you both want to go to court. That's an agreement. People go to court for lots of reasons. And I think they're valid reasons. Sometimes people don't want to decide. They don't want to have to go home with the mediated agreement and say, oh yeah, I caved to this or I gave to that, or yeah, I agreed to this, I agreed to that. Because then they're going to get all of the opinions from everyone else in their world about this mediated agreement that they thought was a good thing that they did at the mediation table. Now everyone else is going to weigh in with their opinions. So they've got that pressure of going home. And
sometimes I think that they really trust someone else's judgment over their own, depending.
Well, it's a judge.
They feel like they don't know. And I'm not sure that they understand all the time that the judge is an expert on the law as it's written. They're not an expert on family life or on your family or child psychology, addiction dynamics. Like any of those things is not what the judge does.
Right. And it's the judge that decides. So there's a lot of power and value in that. People can say, this is what the judge decided. This is what we have to do. So therefore, they don't have to take responsibility for working that out in the mediation. It's off of their shoulders. I don't mean they're trying to avoid the responsibility. I just mean it's so frustrating that no discussion, they don't want discussion anymore, and they want a judge to make a decision for lots of reasons. So I consider that an agreement. I consider that mediation a success because the clarity has come out that they both want to go back to court. And we do not come out of that mediation with a written agreement, which the mediation is, that's the purpose of mediation. But we have come out with an agreement of and I make sure both people want to go back to court, Maureen. I make sure that's what they both want. Because if one doesn't want to go to court and one does, then that's the clarity on the table. So you don't want to, what do you want to do next? That's kind of how I handle it until they get to a place of agreement.
I think that mediation, whether you have an agreement or not, to me, mediation is always valuable because you get more information. Even if you just hear their rants, now you know their playbook, their plans. Like, it seems to me, the difference between like good negotiators and great negotiators is great negotiators know the other side's playbook better than their own. And that's what I see in mediation, especially with some attorneys that, okay, we have to come because we're mandated to come. Neither one of us really wants to settle, which is not fun. Some people stick with that. But you just got all of this information. That at least in itself is valuable. That in itself might help you down the road, both sides. Even just to know, like, how bitter are they? How far can we push this? What do I need to step back from because this is what I'm seeing? So whether there's an agreement or not, I guess I always see mediation as successful in that people get something. Or even just heard, even if the other person will never agree. I just got the opportunity to be heard.
The one thing that I don't like, and I'm so glad MediateGuru has afforded us this opportunity to have a fireside chat and just put our opinions out there. The one thing I don't like is when counsel comes into the mediation, uses it for discovery, so they can kind of pick up on a strategy of the other counsel, and also pushes that mediation into arenas that the mediation wasn't set up for. and they want 6 more things to be tagged onto the mediation. I know there are mediators that will allow that. I'm not a fan of that. And the few times that I have allowed it, I've had parties walk away because it's too much pressure and there's too much take, and there was no giving. So the lawyer is very excited that they can get 3 more things added on to this document, this mediated agreement, or a stipulation for court. And I don't usually enjoy that. I usually push back on that and say, we're here to accomplish the goals of this mediation.
I generally don't let attorneys talk. When I have people that come with attorneys, they can talk to their client all they want, but generally at my mediation, I let the attorney know ahead of time, you're here to advise the client. I'm not here to listen to you. So I'll give them all the time they want alone. But when I say about getting more information, I think I mean more emotional information to really get where somebody's at. Like, is this possible? Isn't it? Do I need to back up a little bit in what I'm asking for? What are our possibilities? More so than discovery, because you're right. I think that's an abusive process. At least it is for me. Yeah. I'm not there to make this an extra discovery process, except for me, I feel in an emotional sense that is a really good part of mediation.
Yeah, I don't like it when it's abused as well. When I feel like, subjectively feel like it's getting abused. What else do you want to talk about?
I think you had mentioned about. Oh, should we take some questions if there are questions?
Yeah.
Garima, Param, or Aditya, are there any questions you'd like us to take, or just to move on? I can't hear Garima. Can you?
I think she has to unmute herself. You're muted right now. There we go. Not yet. You're not audible yet. I think I'm reading. There you are.
Oh, there we are.
Hello.
Hello.
Hello, am I audible?
Yes, there's a strong background noise.
So the first question is, are you seeing any particular type of cases that are not being conducted online? And if so, why? When other cases at that court are engaging in online dispute resolution?
That's a very good question. Are you seeing any cases that you think are not being conducted online because it's online mediation versus face-to-face, Maureen?
I'm not seeing any particular mediation. I am seeing a huge drop in custody evaluation, mainly because I think when people need that time with children, you can never be sure who's in the room if it's online, who's on the other side of the camera from that child. So anyone who does child-centered mediation, if it involves the child, I've seen a drop in that, but not really any other particular genre of cases. Have you seen that, Kathleen?
I'm not sure. I do a lot of family mediations. I do lawsuit mediations, and I've been doing so much training. And I know the small claims court mediations are happening a lot online as well. So I'm not sure. Maybe we can talk about the pros and cons of that as well, online versus more about that versus face-to-face. So I don't know. I'm not sure about that.
I would be really interested to see the statistics on that. That was a very interesting question, to see what has dropped off and what has really skyrocketed.
I would think it's my impression that divorce cases are moving faster because of online scheduling, but that's just an impression I have. But I don't know what's been, left by the wayside or moving slower now because of it. Do we have any other questions?
Yes. There's another question. Have you done mediation in cases, although of civil nature, but there exists criminal aspect also?
I was just thinking about that actually, as I'm thinking about the 24-hour training. You know, I'm going to speak to that, Maureen, first. Workplace harassments, workplace harassment cases, very close to criminal behavior, and often are criminal behavior, that's been kind of stopped or waylaid or just paused to allow a mediation to see what a mediation can do in regard to that. And you've got criminal behavior that's happened, and now we're trying to fix it. Oftentimes because there's a lawsuit waiting for a company, if a director is involved with criminal, with sexual harassment, criminal behavior, bullying, all of that. So yeah, that's criminal. That's what I see in divorce cases that I mediate. Those behaviors of harm to self, harm to someone else is really identified up front, and so then we can funnel those cases in a direction where they belong. Some states will let you move forward as not a mandated reporter, and the mediator can handle them according to what they think is best. In some states, you become a mandated reporter, your confidentiality only has certain parameters and you have to report. So that criminality in those cases gets pushed to another agency or gets reported. Well, workplace harassment, workplace bullying, workplace sexual, improprieties, that's criminal. Maureen, what do you have to say?
I completely agree with you, especially about harassment in the workplace. That often comes up in mediation, where it can be mediated to where there aren't criminal charges, but there are absolute changes. That seems to be happen very often. In my cases, oftentimes there is already like an order of protection in place, or there is some type of criminal charge pending for harassment. And those can be mediated away under Minnesota law, depending. And those can be really tricky because sometimes the survivor of that crime is empowered and says, no, this happened, and I'm going to use this in order to build safety for me and my family in this way. And you really have to find a place where you can respect that wisdom for them. In other places, it's more concerning when it's about something that happened to a child, because who does have that power over the child to decide, no, we're not doing it this way, I'm going to go this way. And that one, I think, takes a lot more time and a lot more reflection. And in agreements like those, especially if they're not attorneys, I really do have them take time before I will sign the agreement. Do you take time between if someone's not represented or if one party is, whether they'll sign the agreement that day or whether you give them, 2 or 3 weeks to check with an attorney? How do you deal with that, Kathleen?
I usually deal with it at the table. If someone wants to check with somebody, I just open up my cell phone, put it on speaker, and we do the checking at the table in private session or sometimes even joint session. I usually let the mediation table handle situations right there. Out of over 800, 900 cases now, mediated cases, one time I've told parties that I had a 7-month relationship with, we have to do a test run before I will let you put this into the agreement. I'm not quite so sure you can pull this off. So please go home and practice for 2 weeks. And we all laughed. And they did. And it worked really well, but they added something else to it as well. So when we finally signed the agreement, it was what they practiced plus the new awareness that they realized they wanted in place. And that became part of the agreement. But typically, almost 100%, my agreements get signed right there at the table after a lot of hard work and after people consulting who they need to talk to, going down into the legal center in the courtroom, in the courthouse, and doing all of that.
I think my added step is usually because of the sometimes deep power imbalances in my cases, where sometimes people will say they want to agree to something solely because of panic and they want out of that room, especially if one party is represented and the other is not. So I usually do a 2-week waiting period if someone is not. And they consult, and I don't think I've had someone change their mind yet, but I feel a lot better if someone is represented and the other isn't. That since I, as a mediator, do not protect their legal rights. Yeah,
I think that's a really good rule of thumb, the 2 weeks. It sounds good. I've never done it, but as mediators, we learn from each other. I'm going to think about that. What we want is a deal, an agreement that works in real life, that can be carried out, that can be walked through, that brings value. It's a win-win for both. That's what we're looking for. And any way we try to get there and do get there brings value to the mediation, to the outcome, and basically brings value in people's lives, which is what I really love about mediation.
I really do love that you pull your cell phone out and say, go ahead. Like, I think that's awesome.
Yeah.
Because in some ways it's a little provocative, but it's also super empowering. Like, we're here to make decisions.
Yeah. You should see me try to get through the court guards, with my cell phone, because typically only lawyers can do that. And I'm like, I'm a mediator. People aren't going to need my phone to talk to somebody. Oftentimes in the mediation, they go, okay. So I just walk right through with it. What else do we have question-wise? Anything before we move on?
Yes. There's a question. How do you deal with the lawyers who are adamant on their point of views?
For myself as a mediator that loves talking to counsel, I always thank counsel for their strong opinions. And I will call a private session with counsel as well to talk to them. I never criticize counsel in front of their clients, never. But I will call a private session, and I've had counsel in the room with 9 people. I've asked 9 people to leave in the past and let counsels. And this is how I said to counsels that were being too aggressive. So counsels, you are doing a very good job at being a bulldog for your parties. I said, but behind you, everyone else has eyes this big, like deer in the headlights, and you've lost them. So why don't we sit here and you two can duke it out and let me know when you're done. Because that's the clarity on the mediation table. And if counsel's being too aggressive, I'll just tell them, we're here for this counsel, and now you're trying to get this, and this. And that is not going to be happening at the mediation table, but never in front of the parties, never in front of their clients. It's about the clarity of the mediation table for me. If someone's being too aggressive, then someone's being too aggressive. And, their speech patterns are too quick. They're creating pressure in the room. Even when someone yells, it compresses the sound waves. And that's just too much aggression. Mediation is not about taking. Mediation is about giving and receiving. So if counsel is not giving and receiving alongside with their parties, their clients, then I'm going to have a talk with counsel about that.
I'm going to say something, and then I realized I did not plug in my computer this morning. So I was like, oh, Kathleen's saying something brilliant. I'm going to duck and no one will notice, but I'll do that in a minute. I have a couple of things I do. The first is I always talk with the attorneys first to make sure that they're aware of how I run things. And I let them know, we're really here to listen to the parties. This can be very valuable for you. And I explain the benefits. I also tell them, you can talk with them anytime you want. I'm happy to give you as many breaks as you'd like. If we're all in one session or caucus sessions, that's fine. And usually you can kind of give them that little look where it's, I'm here to listen to them. And occasionally you'll see the poking or other things like to get their client to stop talking for a minute. But I also work with a lot of the same attorneys over and over. And I ask them what their goals are. Like, what are you hoping for in mediation? How can I help both of you help your clients? Sometimes it is a little interesting. I had an attorney recently who said, please aggressively reality check my client. And I was like, well, I don't know if aggressively. I'm happy to reality check. But I know that a lot of attorneys do use mediation as a reality check on their own clients. Especially when people talk about winning a custody fight and words that let you know it's not about the best interest of the child to them. I think that they use mediation that way, which can be really good for everybody because it really tones it down and it sets a better trajectory for that family.
I love your question. How can I help you help your client? That's a great question. I have never, ever said that. So I need to add that to my practice. It's a wonderful question. Anything else?
Yes, there's another question. Do you feel virtual mediation has benefited you in any ways?
Does mediation benefit us as mediators in any ways?
Virtual mediation.
Virtual mediation, thank you. Maureen, I'll talk. Yes, it's a huge benefit because our client base is vast. Our ability to understand other cultures has increased tremendously. We don't have to get in the car and go somewhere, or get on a transportation mode and go somewhere. We can actually sit here. We don't have to invest time in traveling, so we can actually sit here. I mean, Zoom calls. You can be, you can just come from the kitchen, put on your outfit for your Zoom call, and sit at your desk or wherever. I've done Zoom calls in airports because I've been traveling with clients. I go off to a quiet space and participate in the Zoom call. I've done Zoom calls in restaurants. I've done Zoom calls, in my apartments, both in LA and in El Paso, Texas. It's very convenient to open up your laptop and do a Zoom call. So it's incredibly beneficial, and it's also business-wise, less money that has to be invested in office space, just like any other, business. It's less money out. We can forego that office space and use our home instead. And then, in the United States, you can declare taxes for using your home as part of your business. So there's a lot of advantages. And I like what Maureen said. I think people are feeling safer in the comfort of their home, and maybe even being more forthright because they are not sitting next to the person at the mediation table. I'm thinking that may be something. Maybe Maureen has something to add, which takes us into our topic of, face-to-face versus virtual mediation.
I think it helps make mediation more democratic, with so much less cost that can be passed on to the client. So I think there's a whole new group of people that can now afford mediation. I don't know what the trend is. I do know with many of the ADR professionals, like in Minnesota, are giving way more pro bono hours because they're not traveling. It is so much easier to do a 2-hour pro bono meeting once or twice a week, or once every 2 weeks, than it is to schedule in other ways. So I think it greatly benefits clients and also that expertise. I live in a rural area, and it's very hard to find somebody that's really good with patent mediation or construction mediation, depending. So I think they have access to subject matter experts that really do a better job.
Might this be a good time to move on to our last topic, empathy versus sympathy at the mediation table?
I am so interested in your point of view on this, Kathleen, because as I was thinking about it after you said it, I was like, I have no idea where Kathleen's going to go with that. I'm fascinated. So tell me more.
Oh, I'm so over this. I'm like, I'm so breaking ranks with this empathy versus sympathy topic that seems to be so vogue right now, especially in the United States. I'm a bit of a purist, and I always tell people when I train, the greatest empathy or sympathy that a mediator could show is through 100% accurate clarification of what people are saying. And I'm like, how did this become about the mediator all of a sudden with empathy versus sympathy? Like, why are we talking about the mediator when, this is about our clients at the mediation table? So this is my premise, and this is how I train. Maureen, if you're telling me something and I clarify what you're saying to me with your keywords and I'm using reiteration, that's empathy. That is pure empathy and understanding, where when you hear me say what you just told to me, you get to correct yourself for better clarity. You get to have better understanding of yourself. That's true empathy at the mediation table. If I have ever had any empathetic or sympathetic reactions as a mediator, which I've had, I have literally cried while mediating. But I have not said, excuse me, I need to get a tissue, excuse me. I'm not going to throw the attention back on me just because I'm having an empathetic or sympathetic reaction. I've sat there literally and just cried silently to myself, where finally one of the parties have said, Kathleen, would you like a tissue? And maybe I've said yes, maybe I've said no, but the purist in me says, I don't count. It doesn't matter what I'm going through. What matters is that I'm doing my job as a mediator, and I am 100% clarifying what my parties are saying, so I get it, they know I get it, and then I'm asking them, is there anything else? That mastery question, is there anything else, shows empathy, because I'm not just satisfied with what I've just heard. I'm wondering if they have anything else to share. Do they want to go deeper into their story? That's empathy, Maureen. So that mastery question, is there anything else? It gets said a million times in different ways in my mediations. So I'm wondering, why are we all talking about empathy versus sympathy in the mediation world? Yeah, that's what's going on for me. How about you?
I think I'm a purist as well, in a slightly different view. Like, I think some of the best mediations ever are when I am talking or interacting the least. Like, those are the ones that I feel like are so wonderful, when the parties are doing most talking to each other, and I might clarify or something else, but like the less of me, the better it is, the happier I am with it. Obviously, lots of times you're there for a very good reason, and you need to assist the parties, which is your job. But I think sometimes when we get to a place where they can actually be talking, like, that is rare in my world, and those are the ones that feel like real wins. To me, the most empathetic act is completely listening. And I understand your point about clarity, and I get that too, because those are so linked. Like, you can't ask for clarity without having completely listened. Mm-hmm. And I think for me, that's the highest act of empathy. I do think that mediation is built on empathy, the whole idea of giving and receiving, and of really hearing where someone else is at, being open to hearing. So the whole process is empathetic to me. I think, like, when we're in that mediation, we're really asking both parties to be empathetic to each other. And I agree, the least amount of attention on the mediator, the better. I mean, there have been occasions where obviously you're there for a reason and you need to provide that service to your client. But the less about the mediator, the more about everybody else. Mm-hmm. I agree with.
I think the real issue is when we violate empathy as mediators. The real issue is when we violate validation. I have a really good example that came from someone just recently. They shared with me, and I think they're maybe actually online listening to us right now, where in a mediation where multiple people are present, with like an estate, family mediation, you've got a widow, mother, siblings. Apparently, somebody at that mediation burst into tears in front of everyone. And the mediator said something along the lines of, well, does everyone still want to mediate? See, right there, just to hear that story, to me, that's a violation of validation. It's a violation of empathy. It's a violation of sympathy. It's a violation. So therefore, because there was no clarity, there was no validation, there was no, is there anything else, with that organic moment at the mediation table, we have this huge violation where now someone becomes actually vilified, and there is a close-ended question. Does everyone want to continue? Yes, no, that's a closed-ended question. We're not supposed to be asking as mediators. Typically, we're supposed to ask open-ended questions and make open-ended statements. And then because of the statement created the outburst, this emotional outburst created pressure at the mediation table, guess what everyone said to the mediator? No. Does everyone want to continue the mediation? No. Not really. Uh-oh. So it's more, again, to me, the real question, the real topic should be the lack of it. Why are we violating mediator empathy through clarification and validation and reiteration? Why are we violating that with our parties? And why are we focusing on our own empathy and sympathy? It doesn't make any sense to me.
I think a lot of that empathy is also modeling for the parties by completely listening. That is a horrific story.
Right? I was like, oh my gosh, oh my gosh, oh my gosh. And there, that mediation, you know how I am. I always say that emotions are a third narrative on the table that need to be clarified and validated as well. And no mediator needs to run away from that. As a matter of fact, that narrative that comes from subterranean, you know, from the underbelly of someone is supposed to be appreciated and thank them for, and say, so right now, you know, this is what we have on our mediation table, and clarified and break it all down, and then find out how everyone is doing because they now heard it, right? None of that valuable experience was available for those people at the mediation table. And that is what makes me sad right there.
There's this wonderful example to me in cognitive neuroscience. When I hear, that always comes to mind when I hear mediators talking about leave emotion outside the door or things like that, that are frankly bizarre to me. Because to me, like, the emotion is the first narrative. That's the reality of why we're there. But so in cognitive neuroscience, because you can't do unethical experiments on people and just damage people's brains to see what happens, we rely a ton on people getting hurt and then seeing what happens. And what's so fascinating is, and my husband likes Star Trek with Vulcans and rationality, it's not a thing. So once you damage the part of your brain that deals with emotions, you can't make decisions. You would think, oh, you'll just be logical and rational, but it's impossible. So there's a really famous patient who damaged that part of the brain, and he could not make a single decision in his entire life. Because you need that emotion in order to prioritize. So whenever I hear, let's be rational, and it's like, you can't without that emotion. It physically doesn't work in your brain.
Yeah, that's fascinating. And I saw Garima pop up. I think we might have some questions that she wants us to answer. We've got like 9 minutes to go. Thank you for this time chatting. You should actually be more often.
It's lovely to see you and hear you. I learn so much every time.
Questions for us?
Yes, so there's a question. Kindly suggest how to be a good mediator and what all steps should we take from our law school?
You want to start with that, Kathleen?
Yeah, law schools, a lot of law schools have ADR clinics in them, or ADR clubs, and mediation is typically a part of that. So in law school, I would join that organization. And then also, there are some law schools that actually have active mediation clinics in them where students are mediating real cases from the courts, which I think is fabulous, which I think is the way to go. There's some countries now where mediation is becoming mandated, a program of study in the law schools. And I really think that if law students have the opportunity to mediate, maybe from their second year of law school on, where they're actually rubbing shoulders and actively doing something within the law, I think that's what we should be pushing for. And I think that's a valuable experience. There's a lot to learn being trained as a mediator and then mediating cases. There's a lot to learn from that. It's a dialogic praxis. Maureen and I have learned from each other just sitting here. And that's what mediation is all about. So it has to be practiced before people are typically good at it. You have to correct and grow and applaud what we've done well and grow. So I would recommend joining the ADR part of the law school. If not, I would go to a local mediation center and say, I'd like to be certified, please. You know, if you have time as a law student, get certified and then become become part of that mediation center in your time, and see if you can donate some time to learning and growing with them, maybe an internship or a mentorship with them as well.
Here in Minnesota, which is an international program, the Mitchell-Hamlin Law School has a whole certification process. It is open to law school students from other countries. You take classes in during like a day term in order to be certified, and then they have a clinic, which of course there are clinics everywhere, where law students from the second year onwards are mediating in the courts with real clients. Almost all of that is for low income, which is really helpful to the legal community, to everyone. The other thing I would say is, if you can't find any of those with your law school, find someone that does mediation in your community and beg and plead to follow them. Baked goods usually help.
Yeah. I see Frederica. Hi.
Hi,
Karma,
hello.
Karma's let you in. How are you?
I'm fine, thank you. How are you?
Good.
Thank you for bringing up that example. It was I was very happy to share with you, and I'm happy that you share with all of us now again. It was very painful to watch. I could only but agree with what you and Maureen were saying about interrupting narrative and stopping the empathy and the flow of mediation. That it was really painful to watch, but it was a really great learning experience because I could really see that so many ideas came up to my mind and so many things could have been different if only the mediator was more prepared or maybe more engaged in in her job or something.
Yeah, it's sad when we get something authentic like that at the mediation table and then we just run away from it or we vilify it. Remember in the class, Frederica, we're always talking about how mediation is a journey into the unknown. We do not know where we're going. And it's our job as mediators to hold the space steady and be willing to walk down the different paths that parties provide at the mediation table. And we have to have the confidence, the style, the confidence, and the courage to do that. And that's built. And we oftentimes learn from doing something wrong or seeing something wrong, right? Wrong for our style anyway, wrong for us. And we know that's something we don't want to do ever. Yeah. So that's part of the learning and growing as well.
That's part of what makes mediation so fascinating is that not knowing where it's going, like the curiosity junkie in you is so fascinated to see where we're heading.
That was a great example. Thanks for coming on board, Frederica, and sharing that with us. And
thank you.
You're welcome. And that pain that you talked about, like you're sitting there, you can't do anything about it. Is that what you mean by the pain?
Yeah, I wanted to jump in and say, please let me try something, but I couldn't. I was just supposed to be a silent observer, and probably my face was already talking too much. So
not silent. Yeah.
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 Thank you for bringing up all these examples and sharing your both different but very interesting experiences as mediators.
You're very welcome. It's been fun. Thank you, Maureen. And now you have to become a lawyer because I thought you were one, right? No.
Yeah, I've thought about it, but the only thing I would really enjoy is just saying it depends legitimately. I have a lot of friends that are lovely people and lawyers, so it's possible, but just kidding, law students, you're all lovely. We're very happy you are here, and your expertise is really needed.
Yeah,
one last thing, I just wanted to get one thing out of you, and I know there's only 2 minutes, Kathleen. I saw a question that I just really need to know your answer. Someone asked, what is the difference between empathy and sympathy? And I got to know your take on that.
Sympathy is when you have a reaction inside you. You have this emotional response to what's being said. It's more of a reaction inside of us. It's emotional. That's a lot of sympathy, and it feels like it's the right thing to talk about, and it's really not. Empathy is when you're journeying shoulder to shoulder with the person with their words and their story. You're actually focusing on their story. You're reiterating their keywords, and you walk with them, through what they're telling the people at the mediation table. So it's more of a shoulder to shoulder journey, and sympathy is more of a reaction of emotion inside. Empathy takes a lot of work. Sympathy just happens oftentimes. You've heard people say, I'm so sorry, that this happened. That's not empathy. That's just, a lovely show of sympathy.
I completely agree. And I think sympathy, because it is a feeling, doesn't require imagination. And I think empathy
doesn't require what? Imagination. It doesn't require imagination?
Yeah, I think that empathy, when you are listening, when you're next to someone, when you're going forward with them, I think imagination is a part of that. Trying to really see what they're seeing or hear exactly what they're hearing. Whereas sympathy, I feel, is a very transient. And I think empathy is more constructive, where you're doing something.
You're doing something. Okay. So I guess we say goodbye. Garima, come on up and talk to us in case there's one more question you want us to handle. Otherwise, it was a pleasure. And MediateGuru, thank you again for the most time for everything that you're doing across the world, and you're affording us this opportunity, as well as many other people doing many other things. It's very amazing.
You all
Always
amazing
great
MediateGuru.
having you
Thank you.
both. Thank you so much, Ms. Kathleen and Maureen, for such a vibrant, interactive, and knowledgeable session. I would like to thank all the participants for joining. Thank you everyone for joining us. Also, MediateGuru has launched exclusive career counseling program with Ms. Maureen Erickson Robert Shaw for upcoming ADR professionals. And more details can be found at our website. If you don't want to miss any updates from MediateGuru, follow us on our social media handles and also join the WhatsApp update groups sent in the chat box. Stay healthy, stay safe. See you all soon.
Thank you. Bye, Maureen. Bye, Garima. Spend time with everybody.
Bye.
Bye.